Welcome to Case Series. Don't forget to like, share, and subscribe for more courtroom drama.
With your client, Ms. Guerrero, your client was driving and vaping, and she's charged with intoxication manslaughter. I don't know what the conditions are, but she may not be leaving the courtroom today.
Okay.
It depends on what her conditions are.
Okay. Is there any way to set her up on a computer right now to talk to me in private?
Yes.
So I can find out what's going on?
Yes, I'm going to send you to breakout room number 1. All right. This is what the court has discovered from reviewing the filings. Yes, a motion was filed where this defendant was allowed to have the remote in-home monitor installed in the ignition interlock with an affidavit of non-driving. So she's not supposed to be driving because she's using the in-home. So what she has done is she's violated her conditions of bond. So she's driving and she's supposed to have, she's not supposed to be driving.
This case grips you right from the start. A young woman, once given the chance to prove she could follow the rules, instead spirals into a legal disaster. Meet Miss Guerrero, facing a charge of intoxication manslaughter, a crime that carries up to 20 years in prison. Her actions took a life, and her probation terms were crystal clear: no driving. Yet here we are, back in court, because she ignored that condition. What makes this case haunting is the contrast: her tearful apologies against the cold reality of her reckless choices. Stick with us, because this courtroom showdown is filled with shocking turns, emotional breakdowns, and a sentence that will leave you questioning justice itself.
Okay. As far as I understand, I asked her about having a valid driver's license. I didn't ask her about the difference between the ignition interlock and the home handheld device. I'm sure that she would be more than amenable to have that ignition interlock placed on her vehicle. I do understand that there was an accident and her vehicle was not working, but maybe she has a new vehicle. I didn't get all those details, Your Honor.
All right. So that's what the court has. And that was dated on September 8, 2020. And the court doesn't have an order that's saying that she's going to be driving with ignition interlock. In my understanding, she doesn't have ignition interlock on her vehicle, and she should.
Okay.
So she's going to be going into custody today. She violated her conditions of bond. I can't have someone. And Ms. Smith, I don't take it as true that you committed an intoxication manslaughter, but you're charged with intoxication manslaughter. And one of your conditions was, because your previous attorney came to me and informed me that you would not be driving. And so I allowed you to have the in-home monitoring device installed in lieu of ignition interlock if an affidavit of non-driving was provided. So you're driving and you don't have an ignition interlock. That's a problem. So you're going to be taken into custody today. Ms. Guerrero, she'll be remanded without bond. If you want to file a motion to have the court reconsider that or bring some more information to me, Ms. Guerrero, of course, the court will be more than willing to consider that. But for now, she is, I'm issuing a judge's warrant and she's going to be remanded.
Okay. Well, I'll visit with her tomorrow through the jail and I'll report back. Thank you, Judge.
Notice how quickly the judge lays it down. She wasn't just breaking a minor rule. She was caught driving and vaping, despite an explicit agreement not to drive. This isn't just defiance. It's reckless disregard for a court order tied to a fatal accident. Think about it. She was given a less strict condition, the in-home monitoring device, instead of ignition interlock, solely because she promised not to drive. That trust was broken. What do you think? Should judges be this lenient in the first place? Or is this proof that some defendants just can't be trusted with second chances?
Discovering this case, and did you review it with your client?
Yes,
The court will find that the state is in compliance with discovery. Ms. Smith, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding on the count 2 charge of manslaughter and waiving counts 1, 3, and 4.
No objection.
All right, Ms. Smith, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Do you understand you're charged with the offense of manslaughter? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Do you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Judge, may I clarify one of my responses in response to your question about motions?
Yes.
I said that I hadn't filed anything. I'm not sure if Ms. Corley did, so I don't want to represent to the court because I think she may have filed some evidentiary motions. I did file some non-evidentiary motions, but I wanted to make sure that if Ms. Corley did, I didn't represent that there were none filed.
All right. And I can tell you from my review of the court's docket sheet that there was no motions that were heard.
Okay.
And there were some motions that were filed.
This is where reality slams down. The judge makes it crystal clear. You're going into custody today. No bail, no more chances. This moment is huge because courts rarely like to lock people up mid-proceedings unless the violation is serious. And let's not forget, she's still only charged, not convicted, of manslaughter. But when you violate bond terms on a case involving a death, the system acts fast. It's a reminder that courtroom trust isn't just a formality, it's survival. If you were the judge, would you have done the same here or given her one last warning?
But none that were heard.
I just didn't want to make any misrepresentation.
All right. So the court is finding you guilty of count 2. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
On behalf of my client, Judge, this is a case that was a tribal type case based upon the evidence that you reviewed. My client has made the decision to come in and accept responsibility for her portion in this accident that happened. She's extremely remorseful. She wants to get this behind her and she wanted to say her apologies to the family that the area where this happened, the location was very dark and she just didn't see that there was an accident in front of her. She has Graves' disease and she's been pretty ill at the jail. So she's hoping that this time will pass and hopefully that she can get her life back together. She was a home health care provider and she did help a lot of people while she was out in the field.
All right. Anything from the state?
We have victim impact.
All right. Anything you wish to say, Ms. Smith?
Now pause for a second. Look at her. A year later, Miss Smith appears almost unrecognizable. Stress? Drugs? The toll of jail life? Something clearly changed. This isn't just cosmetic, it's psychological. And this transformation plays into how the court and the public perceive her. Is she a remorseful woman burdened by guilt, or someone broken by the weight of her actions? The way defendants carry themselves often impacts sentencing, whether judges admit it or not. What do you think caused this change? Guilt, lifestyle, or just the grind of incarceration?
I'm sorry, please. I'm so sorry. I'm so sorry for what they lost.
All right. Anything else from either side?
No, Your Honor.
All right. I'm going to follow your agreement. I'm going to sentence you to 6 years in the prison and give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. So, Ms. Smith, there's going to be a victim impact statement. What I can tell you is I know that sometimes emotions and tempers run high, because in this court, we'll deal, as your counsel will tell you, and the state will tell you, we're dealing with serious cases, major felonies. But I do require that everyone treats everybody with respect and kindness. So
Here it is, the gavel moment. The court officially finds her guilty of manslaughter, a second-degree felony. Now think about this. The original charge was intoxication manslaughter, a heavier offense, but the plea deal shifted it to simple manslaughter. This is where the system balances evidence, plea bargaining, and efficiency. Prosecutors often drop higher counts to secure guaranteed prison time without risking a trial. But here's the real debate. Is that fair to the victim's family or just a necessary evil of modern justice? This moment is raw. Miss Smith breaks down crying, "I'm so sorry for what they lost." On the surface, it sounds remorseful. But dig deeper. Notice how vague it is? She doesn't fully articulate her responsibility. She blames circumstances like darkness and leans on illness and fear. The courtroom is no stranger to tears, but judges and families often look for accountability, not just emotion. Here's a hard question for you. Do you think she's truly sorry for taking a life, or just sorry for what's happening to her now? And there it is, 6 years in prison for a crime that could have carried up to 20. 6 years for a life lost. This sentencing sparks debate. Is it too light, considering the devastation? Or is it fitting, given her remorse and circumstances? Judges weigh a ton of factors here. Her plea, her apology, the nature of the crash, and her prior violations. But to many, 6 years for killing someone